Right. I'm so pleased to be joined by Tosh today. So thank you so much for coming along. So just for information for our listeners, Tosh runs an employment law practice that also covers HR and all of those good things that we normally talk about. So today we're going to have a bit of a chat about contracts and all of the fun and not so fun stuff that goes with that. And I should say hello. Hi Tosh, how are you doing?
Hi, Trish. Thank you very much for asking me to participate in this. I'm very grateful to you.
Oh, awesome stuff. Okay, so let's start off with kind of a basic question then. So why is it important for companies to have contracts of employment?
So the reality is, the contract of employment should be an understanding between the employer and the employee what the expectations are, right?
Mhm.
If everybody's living happily ever after, you don't need a contract. Everybody knows what the score is. Everyone knows what the deal is. I know a lawyer saying you don't need a contract, but you don't. It's only there for what purpose? So there's certainty of terms. If you're my employee, Trish, you know what I expect of you. This is what I expect you to do. This is how I expect you to do it. This is when I expect you to do it. And in return, this is what I'm going to give you, or this is what I'm going to do for you. So
Mhm.
when do you ever look at that contract? Normally, if there's a dispute of some kind, well, what was the deal? What is my bonus entitlement? What does your policy say? Or those sorts of situations. But otherwise, that's the only real purpose is certainty of terms and understanding each other's expectations. And then if things go wrong, well, that's the document you refer to that shows it. In reality, you could even have emails. It doesn't have to be a contract as such. It's done in a contract because it's one place, all the terms in one place. Everybody signs it. They show there's an agreement, and that's why it's done that way.
Mm. And when should someone be issuing a contract of employment? Because I think one of the things I'm seeing kind of in my day to day is companies that haven't issued contracts and are just kind of bumbling along, and people are all right. But when technically should they have issued them?
So legally speaking, they should do it within 8 weeks of them starting. Within 8 weeks. The strange thing about it is if they fail to do it, there's not a legal consequence. The
Mhm.
legal consequence only comes about if you are able to claim unfair dismissal. And then on the back of that, you can say they failed to provide your terms and conditions within the first 8 weeks. But to claim unfair dismissal, you've got to be there for at least 2 years.
Mhm.
So the law says that. In reality, when should you have it? Right at the start. You don't, what I might say and what you might hear might be different things.
Mhm.
So the idea is have it in writing. Let's get absolute crystal clarity on the lot. Generally, for the employee, it's going to be, well, what am I getting out of this? And generally, for the employer, this is what I'm expecting from you. This is what I want you to deliver. So if you
Mhm.
have those things clearly spelled out, you should get that from before day one, right? Here,
Yeah,
I'm going to offer you a job. Here's the terms. You interested? Great. Then let's start on that date.
love that, and that's a really good lesson for a lot of businesses. Um, I've seen a lot of companies lately downloading templates off the internet, and some of them have been good, and some of them haven't really been good. What are your thoughts in terms of how businesses can get fit for purpose contracts of employment?
It's quite simple, isn't it? It just requires a bit of thinking about it. So can you use a template? Well, if it suits you, then great. If it covers everything you want in the way that you want it, brilliant. So the more basic the arrangement is, or perhaps the more junior the level of employment, perhaps you can use a template. That's not a problem. But when you get to a certain level, perhaps at management level, or perhaps if you're talking about things like bonuses,
Mm,
a lot of contracts will say a discretionary bonus, which kind of says, well, we'll pay you when we feel like it. But in reality, there's got to be a way that is exercised.
mm,
So they should have that clarity in there right at the start. Everybody knows what the deal is. I know I'm sounding like a stuck record now, and that will just avoid so many headaches down the line. So if they're not fit for purpose, the question would then be, well, why? What's the purpose?
mm,
And I think generally speaking, Trish, it might be that it's just not covering certain things that are bespoke to a workplace situation. What's your mobile phone policy? So in my workplace, you can answer calls, and you can answer personal calls too. Just don't take the mic. Sit there chatting to your mate all day. You know what I mean? We're all human beings. So whereas other policies they might not allow that, for example. So when you're saying they're not fit for purpose as an employer, you just have to think, well, what do I want to tell my staff? If
mm.
you think about it another way, and it won't necessarily be in the contract, Trish, it'll probably be in the handbook. And the handbook is usually non-contractual. And the handbook just says, this is how we do stuff. This is the way we operate. This is the way we behave. This is what happens if you're pregnant. This is what happens if somebody bullies somebody. This is what happens when you use the phone in the workplace. So it's just clarifying, this is how we roll kind of thing.
Mm, mm. I love that saying. I've got that on a hoodie. Um, I suppose that's a really good point to pick up on. So a lot of companies that I've worked with in the past don't necessarily have employee handbooks, or they do have them, and there's a bit of confusion between what should be in the handbook and what should be in the contract. Now, I know it's a fairly big question, but have you got any tips or hints on what should be where and how handbooks should be used?
I have a very, very clear answer for that, Trish. So the contract is typically the thing that people refer to quite quickly because it relates to your pay, right? And it will also, sorry, somebody doesn't know they were doing recordings. How can they call me when I'm in the middle of a recording? Sorry about that. The contract should be the main terms: pay, hours, place of work, pension contributions, sickness. So just the key things that might be more relevant on a day-to-day basis, right? Whereas the handbook is something when something hits the fan, let's say, or you don't know what to do about something. So you know what? You've got a gripe. You've got a grievance. Grievance policies in the handbook. You know, if you're going to be disciplined, well, how does the disciplinary process work? It's in the handbook. Holidays in the handbook. Sickness, the full sickness policy in the handbook. So the way to think about it, I think, is the handbook is, as I say, this is how we operate. So any situation at work you're not sure how to deal with it, it'll be in the handbook. Whether it's maternity, paternity, family-friendly policies, whether it's expenses, whether it's bribery act, you know, what's covered, you know, all those things should be in there. But in very basic terms, it's telling staff what we expect and the way we behave, and perhaps what the consequences will be if you don't toe the line with what we're asking for, okay? Whereas the contract is much simpler. Pay, hours, so on and so forth. So that when you have your appraisal, you're not necessarily going to be looking at your handbook. There's no reason to. But unless you want to understand the appraisal process, I suppose, but you would take your contract to say, well, look, I've been on this for this number of years. I'm expecting this because of, you know, I've delivered on that and so forth. So that's how I would separate the two.
Fab. Cool.
Okay. I want to mention one other quick thing, Trish, which is, a lot of companies don't have a handbook, right? It just says this is how we operate. So why would you need a handbook? There's two reasons. Number one is because, it shows employees how we operate and what we expect. Number two, if things go wrong and they end up in an employment tribunal, it's the documents that the court's going to look at first, right? Documents win cases and it's witnesses that lose them. So what they will say is, okay, what's your policy on this particular situation? Let's say it's bullying and harassment in the workplace. You go to the handbook. Now, obviously, it's not worth the paper it's written on if they don't actually implement that policy and haven't trained their staff on it. But assuming they have, that really gets them off the hook on a lot of types of situations. So, for example, if there's a sexual harassment case, Trish, and one employee, a colleague, sexually harasses somebody else, let's say they go to the pub after work. So it's like work colleagues together and it happens. So you're not even in the workplace. There are cases that say that that's defined as what's called in the course of employment still. So the employer is still responsible for the actions of their employees, even if it's outside work, if you can argue it's kind of in the course of their employment. You know, they only know each other because they're working together. It seems a bit far-fetched, but that's what it is. Now, in that particular situation, they could rely on the handbook. Well, look, handbook, we explain in the handbook, this is what the situation is, this is what we expect. You know, it sounds silly, isn't it? Don't sexually harass people, obviously. But the way that the law operates, without sounding patronizing about it, is they treat employees like they're children that don't know any better. So you've got to spell out the most obvious things of what you expect and don't expect. And when you've done those things in the handbook, that gets you as the employer off the hook because you've done everything you could reasonably, practically do to stop that type of behavior from happening. That's the second reason.
Would you give businesses any advice around being clear that handbooks aren't contractual? So whenever I write a handbook for a company, I always make it really clear that nothing in the handbook is contractual and obviously it's subject to change. Is that something that you would recommend your clients do?
Yeah, absolutely. So because what happens is they assume that they have to follow the if you put it as contractual, you're obligated to follow what the process is, or you're in breach of contract. And the consequences of a breach of contract is, well, what's the loss that's been suffered as a result? So if you've just taken a shortcut, you might end up having to pay a few more weeks' pay because you would have taken longer if you followed the contract, for example, right? So generally, exactly what you've said, Trish, right in the opening, you say it's non-contractual, it's a guide. It also gives the employer flexibility to move things around, right? Imagine you just say, you know, a specific director will chair your meeting and it's in the contract. Well, what happens when that guy leaves?
Yeah.
Or let's say that they're off sick. Well, does everything, you know, come to a halt? No. So you give yourself some flexibility by saying it's a guide only and not contractual, and you spell it out at the beginning.
Fabulous stuff. Alrighty, let's get into the nitty gritty a little bit more. Thinking about contract types. So I get a lot of questions around 0 hours or casual hours contracts. And sometimes there's a bit of confusion about whether or not they're a good thing or a bad thing, and kind of when and where they're going to be phased out. So can you tell us a little bit more about those?
So 0 hours contract means there's no certainty of hours that you're going to get, right?
Mm-hmm.
And whereas an employee, if you think about it, when you think about it, there's three things in law that make an employee, okay, that requires to be an employee. Number one is personal service. So you've got to provide it yourself. You can't get your mother, your brother, your mate, or somebody else to do your job. Okay. Whereas as a self-employed person, I can get one of my colleagues to obviously do the service for my clients instead of me. So personal service. Second thing is what's called mutuality of obligation. So as an employer, I've got an obligation to give you work, and you as an employee, you've got to take it. Obviously, assuming it's reasonable, it's part of your job, right? I can't get my lawyers to clean out the dustbins, for example, suddenly out of the blue, right? So it's not part of their job. So mutuality of obligation. The third thing is control. As an employer, you can tell your employee what to do, when to do it, how to do it, the place of work, all those things. Possibly not quite as tough as that, but you know what I mean, right? They get to tell them what to do. There's control. So with the casual contract, there is not that mutuality of obligation. If the company wants to say, can you take this job and do this, they can say no. That's it, right? There doesn't have to be personal service. So if that person isn't around, somebody else can do it. Doesn't matter. And the third thing is control. Well, there has to be some element of control about when the job is done, right? But what the specifications are. But that's about it. That's about as far as it goes. You know, if somebody is engaging me, I could never be there regarded as their employee, because I will do the job according to their deadline, but how I do it is up to me, right? I've just got to deliver. So 0 hours contracts suit a certain level of flexibility for certain individuals, and they don't have the same rights as employees have, right? The employees have the right to claim unfair dismissal, and they have maternity rights, family-friendly rights, all those sorts of things. So they don't have that sort of entitlement. But as most of the time, it tends to be for either lower level work. So a lot of cleaners are on 0 hours contracts, for example, and something that's more like a minimum wage type of work. Or it will be something to do with flexibility, where people just want to be able to work as and when. Inevitably, though, I suppose, Trish, that what happens is there's like a rota system. So if you're a part of a bank member of staff and you're on a casual contract or 0 hours contract, and if you keep saying no, I suppose eventually they'll just stop asking.
Yeah.
But there's no obligation either way to them to take it or not to take it. Although casual workers still get things like holiday rights.
Okay. Awesome.
So does that answer your question?
Yeah, no, it does. It does. I think it just gives a nice overview for those people who don't necessarily use them very often or want to use them and they're not sure kind of how they work. So it's really helpful.
For employers' point of view, Trish, I suppose, you know, they avoid the legal rights that employees will have, so that might suit them. But the problem is the way that the law looks at it is over the course of time. Let's say you have a 0 hours contract person, but actually they're working pretty regular hours every week, and they do that over a significant period of time, which actually makes the 0 hours a load of nonsense. Or a load of tosh. I'm the only one allowed to say that. I'll say Trish. And make it a load of tosh, then it doesn't make sense, right? It's got to be reflective of it. So the way the law looks at it is, if it quacks like a duck, walks like a duck, it's a duck.
Yeah.
So that means whatever you label it as, it's got to be actually the way that the parties conduct themselves that will ultimately determine it. It's got to be reflective of what the contract actually is.
I think I've seen in the past a lot of people who will use these kind of contracts, but you've got to bear in mind what you've just said. If it's a duck, it's a duck. Why are we pretending it's something else?
Yeah.
Okay, so what about freelancers? So that's another question or kind of issue that I see when I'm working with my clients, that people will have freelancers working for them but won't necessarily have any kind of contract in place, and then it's a bit awkward and they're not really sure how to bring it up. What kind of contract would you recommend that businesses have with freelancers, and who should be providing the contract? Is it the freelancer or the person that's kind of getting the work and the service from them?
So ultimately, freelancers or self-employed people or contractors are people that are providing their services for whatever reason. I am one of those people, for example, and I wouldn't expect an end user, let's call them, to provide me with the terms and conditions, because I'm the one that's offering my services. What I would expect is what the parameters of their expectations are.
Mm-hmm.
There might be two things. One is my terms and conditions of business. And the other thing might be, depending on the nature of your work and what you're offering, is a separate contract with them that is more bespoke to that specific situation. So certainly you should always start from the I'm going to call them the subby, from the contractual, the freelancer. But it wouldn't be unusual for an employer to then renegotiate those terms. As for not having one, again, it's foolish, because if things go south, or when they go south, in many cases that I obviously end up seeing, the first thing you look at is the contract. Oh, we didn't do a contract, just a handshake. So now what are we going to do? We have to look at emails. Maybe they don't even have a lot of emails about it. Just start then, here's some money. But everything else was verbal. Well, now it's coming down to prove what was said, what was agreed, and all those sorts of things. You're digging around now for things that could have just been put down in paper quite easy at the beginning. What are the circumstances you've seen, Trish, what have you seen happen when people are working without a contract in those sort of situations?
To be honest, it's exactly as you say. It tends to be that when something goes wrong, or when there's a bit of a dispute about what it is that the person's supposed to be doing, then there's nothing to kind of, tangible to grab hold of, and there's a bit of he said, she said, and it's kind of more of it damages the relationship more than anything, I would say. I've not so far, obviously, I'm not in exactly the same line of work as you, but I've not seen anything that's gone to a tribunal stage. It's more of that relationship's then damaged, and it's kind of just sour grapes, if I'm honest.
Absolutely right. And when does that happen? It's when the expectations haven't been met. So let's say an employment tribunal will deal with employee stuff. If it was a freelancer, that wouldn't go to an employment tribunal, that would go to a county court or high court, right? It's a different forum. But the reality is it still just comes down to if people aren't delivering, that's when they start to look at the contract and the terms and whether they want to terminate it or what have you. So remember, the contract is there if things go wrong. So it's like it's better to have a gun and not need it than need a gun and not have it, I think is the phrase.
Oh, wow. Okay, so we've talked about freelancers, we've done 0 hours contracts, permanent contracts then. What sorts of things do you see employers not do very well when it comes to permanent contracts?
A couple of things. First of all is doing the probationary period effectively. So what happens is somebody goes to recruit. It's taken a long time to recruit that person. Maybe they want to get bums on seats. And then what happens is they get a bum on a seat. And it's too late. They made the decision, right? They've recruited that person. And then what do they say to themselves? They say, oh, you know what? I'll just see how it goes. I'll see how it goes. Yeah, the old shig. So we're going to see how it goes. And guess what? You should listen to your gut, because you knew it was always not going to work out. So do a proper probationary period. Because you're never going to meet the real person at the interview. You're only going to ever meet the best representation of them with their false moustache and their hat and coat. So, and then when that all comes off, and then you start to see it, go with your gut. There's a reason you expected that person to go there. What people also often don't do correctly when they're in these sorts of situations, when they're making somebody permanent or not, is look at the qualities of the individual. Obviously, the skills in the job are important, but if they're an absolute pain in the neck or toxic, none of that's going to matter. So have one of the things I've got in my recruitment process is how nice they are as a lawyer. How weird is that? Because we have to deal with difficult situations. So it's very important to me that I'm working with people who are just nice, and friendly, and don't have a negative outlook on life in that sense. So I'm suggesting the number one flaw doesn't tend to be the skill set assessment. It tends to be the character assessment. They don't actually look behind who the person is. Don't look at them as an employee. Look at the whole person. What do they want to do? What is their development? How does that align with what you're doing? Can you see them going where do they want to be within the business actually? Do they have a plan, or is it just turn up for a job 9 to 5 or what have you? But knowing your people in that way rather than just as employees, I think fundamentally makes a massive difference. Plus, you create alignment, loyalty. People seeing their employee actually gives a damn. It makes a big difference.
Where do people stand with probationary periods if the probationary period, for example, is set at 3 months? They'd kind of let it slide and let it drift, and then I'd say 4 months in, they realise something's wrong. How do you deal with that as an organisation?
So I suppose there's two things. Normally, the difference between the probationary period or after the probationary period is notice. So notice might be a week in the probationary period, and then a month once it's successfully done. So what I would suggest you do is What I would suggest is in the contract it says it's 3 months, but you've only passed it when it's been confirmed in writing, because life gets in the way. So and that's why month 4 came and we didn't get around to it. Better still, obviously, prevention is put something in the diary in month 2. Let's have a review now. How's it going? Okay, then we've got another 2 more reviews within the last month, 2 weekly, let's say. Then you're really sure, is this the right person or not right person? Or do we need to extend it? So where there's a dispute is where they fail to extend the probationary period, or they try and do it after the 3 months have expired, for example, and then they want to dismiss. And now the employer's saying, well, hang on a minute, I passed that probation period. And they said, no, you didn't. We didn't confirm it. We didn't say that in the contract. You've got to put it in there that says that. Otherwise, it's automatically passed by time alone, right? So that is where it needs to be dealt with, is put something in the diary in month 2. Don't put it in month 3.
I love that. That's a golden piece of advice. And that would have saved quite a lot of people a lot of stress that I've worked with.
Yeah, I mean, ultimately, they're going to, it's a 2-year rule, Trish. So, an employer can dismiss an employee for any reason they like, any reason, as long as it's not discriminatory or automatically unfair, obviously. So they just don't like them. So the issue really comes down to not that they can't get rid of somebody, it'll just cost an extra 3 weeks, or something like that pay, which obviously will then depend on how high a level of salary they are and so forth. So it is people ignoring their gut instinct, I think.
Yeah, no, I completely agree. And I totally think that you don't really see the real person until they've been there 3, maybe 6 months, because you can only kind of pretend to be amazing for a short period of time.
yeah, correct. And after a while that will come through, and if there's something you're not sure about, then you extend the probationary period. But don't just leave it with right, we're going to extend it for another 3 months. You need to tell them, what is it that you as an employer want to hear, see, and feel? Because there's no point being Superman and walking around like Clark Kent. They've got to actually show who they are, but let the employee know. It might seem obvious to you, but it isn't always obvious to the individual. They just think, well, I'm doing my job. But, nobody's seeing it, or something like that.
Another thing that I see, and I feel like I'm jumping about a little bit, but it's in the same thing. So another thing that I see in contracts is kind of badly drafted pay in lieu of notice or pylon clauses. Can you tell us a little bit more about kind of what that means? Obviously, I know, but for our listeners and watchers, and is there anything that people can do to make sure that those clauses are drafted properly?
So Pylon stands for payment in lieu of notice. And what that basically means is you don't need to work your notice period. We'll just give you the money instead. Typically, they have a pylon. You need to have in the contract. I'll tell you why in a moment. But so you have it in the contract, and that allows you to terminate somebody's employment today, and then they just get the notice paid as money. Notice period as money only, but they don't get any of the benefits that they would have got during that time. So it just shortcuts the process, right? If you do a payment in lieu of notice, and there's no payment in lieu of notice clause in the contract, it's a breach of contract, which means you'll be entitled to your losses as a result of that breach, your losses being anything you would have benefited from during that notice period, because there's not in the contract, right? Another thing is, if you breach the contract, then that would also allow an employee to not be bound by their post-termination restrictions. So if you breach the contract fundamentally in that way, they could basically go and start stealing all an employer's clients, for example, right? Because the restrictions wouldn't be in place anymore. In terms of badly wording, I haven't seen any that are badly worded, but what I've seen is that they either have them or they don't. And then when they want to exercise it and they don't, that's the problem. What's your experience of badly drafted clauses?
So mine, it tends to be around exactly as you said, either they're not there or when they are, they're just not quite well worded. So things like not explaining that the pylon will only be in relation to the basic pay. It won't include things like bonuses. I hope I'm not saying the wrong thing to an employment lawyer. She becomes very nervous.
Sweat.
Yeah. So those kind of things, or just including things that aren't relevant in any way, shape or form, really, making reference to kind of statutory notice when actually the notice that they're given is more than that. Things like that, where it just, to you or sloppy. It's sloppy. But if I was an employee reading it, I'd probably go, oh, can't make sense, I'd sign it. But as you say, you get stuck.
You'll only look at it when it becomes your notice period and then the payment. You're absolutely right.
Yeah, exactly. Okay, so I feel like we've covered some pretty decent ground. Is there anything else that you think it would be useful for employers to know about having contracts of employment?
I have one cases. There's a certain clause in a contract where it says that it governs the entirety of the understanding between the parties, and things will go to court, go to tribunal, And I remember we spoke before we were starting doing this recording, Trish, and I said, you were going to ask me about any interesting cases. I said, they're not interesting. There's no interesting contract cases. But so somebody was arguing that, that the reality of the situation wasn't reflective in the contract.
Mm-hmm.
But then as I went through my cross-examination with them, I took them to the clause where it says, it governs the entirety of the contract. I said, do you acknowledge that? And he said, yes. As soon as he acknowledged that, everything else he said went out the window, because he just said under oath that the contract the entirety of the contract was governed by this clause. So you can see it can be very powerful if you get your contracts drafted correctly. And remember, whether it's somebody like yourself, Trish, or somebody like me, the idea really is to avoid any pitfalls. Because obviously we've got a crystal ball, because we deal with terrible situations quite a lot, disputes, people are being angry with each other and doing all sorts of things. So it's good to have somebody who has walked that path, seen what could happen, and then just covers it in the contract. It doesn't have to be War and Peace. It doesn't have to be ridiculously expensive at all. You should be able to, if you're not going to get a template, a few £100 for a contract of employment, I would have thought, maybe 5 or 6 or 7 if you're going a bit senior, maybe £1,000 if it's a director. But you shouldn't be looking at an exorbitant amount of money. And my point is that it's an investment, because the return is protection for you and the business and understanding what's going on, because it's evergreen, right? Once you've got the contract, you can keep using it. And then you just need to update anything with any changes of the law. So that would be the only other thing I would say about contracts as a bit of insight.
Awesome stuff. Thank you so much for your time. It's always lovely to talk to you. I'm not going to lie, it's just an excuse to be able to have a chat with you.
You don't need an excuse. Thank you so much, Trish. Really, really enjoyed that.
How can people get hold of you? So if they want to talk to you directly and benefit from your advice and guidance, where are they going?
So I'm the only lawyer with my name on the planet. Surprise, surprise. So if you Google Tosh Polpitiye, you'll find me. My full name is Tashara, but you'll see that if you find me. I'm on LinkedIn. I can give you my details if that would help, Trish, to pass with it. What we do is, what we realize, it's very daunting speaking to a lawyer. So what we have is a free consultation, which is basically, give us a ring, let's talk to you for an hour, and I promise you there'll be a solution to whatever problem you have. And then if you want us to do it afterwards, then we'll agree something like a fixed price. We don't do hourly rates. So that's how they can just reach out to me, search me. The company's called Astute Law, and happy to help, really happy to help.
Awesome. An hour is really, really generous. I'd definitely be taking that up if anybody needs help from Tosh.
Yeah, sometimes it's just people just want a right direction, and they don't need to spend through the teeth just to get a bit of helping hand. And then once they know their choices, then they know whether the juice is worth the squeeze, so to speak.
Yeah. You've always got a really good phrase for everything. I love that. We've had Superman. There's juice.
I'll keep them coming. Thank you very much, Trish, genuinely.
No worries, thanks so much for your time. So for listeners and watchers, obviously podcast and YouTube video is for guidance only. Make sure that you do take your own legal advice, and if it's on anything that we talked about, call Tosh.
Thanks very much. Bye everybody.
Bye.